criminal law. The Juvenile Justice Act is a criminal law. The Protection of Civil Rights Act, which specifically criminalizes untouchability, is a criminal law. In fact, very interestingly, it's the Protection of Civil Rights Act of 1955, which also, if you are found guilty under, would ban you from elections for 6 years after you've been released from jail on a conviction under the Protection of Civil Rights Act of 1955. So basically, what you have is a civil law and a criminal law. Apart from the fact that in criminal law you go to jail and the civil law you don't, there's a finer difference. The difference is criminal law is an exact law. For you to be found guilty, there has to be no reasonable doubt that you are indeed guilty. But when it comes to civil law is a probability law. It's a proximate law. For you to be found liable to pay compensation, it sort of seems like the most likely thing to do. It may not be exact, it may not be precise, but it is most probably right. Then you have laws based on depth. A general law or a specific law. A general law is a law which covers everything about a specific branch in one place. For example, the new criminal law, the new criminal code, the new penal code. It has a brand new list of crimes, a brand new list of punishments. Most of them have been carried forward from the older IPC, but it is a collection, it's a database of crimes and punishments. Whereas the Juvenile Justice Act very specifically deals with child criminals. The Protection of Children Against Sexual Offences, POXCO, is a law specifically dealing with sexual crimes against children. So that's the difference between general law and specific law. The general understanding is specific law will override the general law in case there is a conflict. And you finally have the purpose of the law. Substantive and procedural. A substantive law is a law which says X is right, Y is wrong. A procedural law says, okay, something has happened to you which is wrong. Maybe Y has happened to you. How do we go about making Y right? What is the procedure? For example, let's say the new criminal law is a substantive law. The new procedural law is a procedure law. The new criminal procedure law is a procedural law. So for example, let us say theft. Theft is a crime, is substantive law. What police station to go to, what kind of a complaint to be filed, what kind of an FIR could be possibly registered is all a matter of procedure. So that's the difference. So for example, let's take the case of the new criminal law. The new criminal law is a public law, it's a central law, it's a criminal law, it's a general law, and it is a substantive law. And this is how laws are bifurcated. Now, if there are laws, laws can be changed, laws can be added, laws can be removed, laws can be amended. Because at the end of the day, democracy is about majorities. And therefore, we must understand majorities. Majorities is the celebration of democracy. It is the mathematics of democracy. It's the science to democracy. What is the number of yeses you need for something to happen? Majorities are applied in two ways. First, to laws, and second, to legislative procedures. What we are primarily concerned in the first lecture is application of majorities to laws. I'll give some reference to legislative procedures, and there are several additional special cases such as emergency, such as state resolutions, and so on and so forth. We'll come to that in a while. But generally, majorities are things that you need to do to pass laws or to pass certain procedures. Procedures to make certain things happen. Now, there are essentially two ways to look at it. One, majorities that require more than half of something. And two, majorities that require more than 2/3 of something. The difference is, if you require more than 2/3 of something, what you require is a 2/3 majority. And generally, things that will require more than 2/3 of something will generally have a little bit of a federal impact, will have a little bit of a center state impact. Now therefore, let's understand this. When we look at more than half of something, there are essentially three majorities that we're referring to: absolute majority, effective majority, and simple majority. Let's start with the highest, because that's how the graph gets to be plotted. Now, absolute majority. Absolute majority is more than half of the total strength of the temple of democracy, which is the legislature, the specific legislative house. More than half of the total strength. The purpose of the absolute majority is to establish a majority in a certain house. Now, India is a parliamentary democracy. At the union level, we have a bicameral setup. So the Lok Sabha is the lower house. All states in India have one lower house. Some states in India also have a second house, like the center. But the purpose of the absolute majority is to establish majority at the lower house. So therefore, absolute majority is only used in lower houses. So what are our lower houses? The Lok Sabha, the legislative assemblies of the states, and those union territories which also have legislative assemblies. In India, we're supposed to have three: Delhi, Pondicherry, and J&K. And out of the three, we have two functioning legislative assemblies with Delhi and Puducherry. So that is effectively what is called absolute majority. More than half of the total strength used to establish majority. This half could be with a single party. It could be a bunch of parties put together. As long as you have more than half of the total number of seats in that house, you have majority in that local house. So for example, the Lok Sabha. Let's say the Lok Sabha has about 543 seats. These 543 seats come from 543 constituencies across the country. Whichever party or a collection of parties gets more than half of these 543 seats, that's about 273 seats. This is your magic number at the Lok Sabha. As long as you can do that, you have what is called absolute majority. That's the purpose and nothing else. Absolute majority is used to establish majority so that you can decide who your ministers are going to be. Then you have effective majority. Now, a simple way to understand this is, for example, there is a classroom. There are some decisions that can be taken by everybody who's enrolled in a course. There are some decisions that have to be taken by everybody enrolled in the course on the first day. That's like absolute majority. There are some decisions that will have to be taken by only those students who are currently enrolled in the course. Some of you may have withdrawn. So that would mean effective majority. And some day-to-day decisions could be taken by the students who are currently present in the class and wish to take a decision, that is present and voting, or simple majority. I'll come to that. So, effective majority. Effective majority is more than half of the effective strength. What is the effective strength of the house, the true strength of the house, a strength that is valid. That means the total strength minus the number of members who have either died, have been disqualified, or have been resigned. So total strength minus DDR gives you effective strength. So more than half of the effective strength is called effective majority. This effective majority has one single purpose: to remove the class monitors of the house, the presiding officers, and therefore it is applicable to all houses. Lok Sabha and Rajya Sabha at the center, legislative assemblies of all the states, legislative assemblies of union territories, and also second houses of the states that have second houses, the legislative councils. And you have presiding officers. You've got speakers and deputy speakers in the lower houses. You've got chairpersons and vice chairpersons in the upper houses. There is just one minor special category, and that is the chairperson of the Rajya Sabha. The chairperson of the Rajya Sabha is the vice president. The vice president is ex officio the chairperson of the Rajya Sabha, which means whoever is the vice president is also the chairperson. So when you're removing the chairperson of the Rajya Sabha, you are removing the vice president, which is why in the removal of the vice president, you will have effective majority in the Rajya Sabha, and after the Rajya Sabha has done its job, you would have what is called simple majority in the Lok Sabha to confirm the vice presidential removal. This is effective majority. Once we've understood effective majority, we then understand the most widely used majority, which is simple majority. More than half of the number of people in a house who are present and are wanting to vote. This could be a yes vote, it could be a no vote, but they're wanting to vote. So more than half present and voting means more than half of the people who are present and have voted yes in your favor. Now, you would use this in all houses: Lok Sabha, Rajya Sabha, assemblies, legislative councils, legislative assemblies of union territories, everywhere. The idea is you will use simple majority to add, amend, or delete any law which is not the constitution. So any law in the country, a central law, a state law, which is not the constitution, you will simply use simple majority. Any law. The new criminal law, simple majority. Juvenile justice, simple majority. The new telecom bill, simple majority. The, let us say, the Protection of Civil Rights Act, simple majority. The anti-doping law, simple majority. Any law which is not the constitution will be changed through a simple majority. And you will also use this to change some parts of the constitution. Those parts will explicitly mention that these are not branded constitutional amendments under 368. For those kinds, you will use simple majority. And because majorities are also about procedures, you will see simple majorities to be largely used for parliamentary motion. So technically, anything which has the word motion after it, no confidence motion, censure motion, no confidence motion, calling attention motion, they will all be used using simple majority, right? So all of these are in the more than half bracket. Then you have the federal majority, more than 2/3, special 1, 2, 3, and 4 in ascending order of strength. This was in descending order. So special majority 1. Special majority 1 just requires more than 2/3 of present and voting, just a notch higher than simple majority. And I'd like to generally and colloquially call it as a resolution majority. you use special majority 1 only and only in 2 cases. It is to authorize. When the Rajya Sabha has to authorize the parliament, which includes itself, to create a new All India service, you would require special majority 1. Similarly, if the state legislative assemblies want a legislative council, they want to tell the parliament that they want a legislative council. In that scenario, they will pass a resolution saying, hey, we want a legislative council. We are dead sure about it. None of this means that the council has been created or a new All India service has been added. It simply means that once the Rajya Sabha has passed a resolution, now the parliament can start the process of making a law on All India services. If the parliament wants, they can make a law creating a state legislative council for a specific state. That is generally what is meant by it. Now comes the most misunderstood majority, which is special majority 2. Special majority 2 is essentially a dual majority. Now what happens here is, you will ask the same question to the House and ask them to vote twice. One, and the second time to reconfirm. So are you sure? Are you really sure? Now how does this work? When you ask the House for the first time, they need to say yes with more than half of the total strength, which means you already have a gigantic approval. Now just to be doubly sure, a little bit of a nudge, you ask the same House the same thing again, and therein they have to answer by saying more than 2/3 of present and voting. Theoretically, this could also mean that the present and voting strength could be similar to a total strength, which is a rare scenario but is possible. But in special majority 2, you ask the question twice. The House votes twice. There have been several instances when the House has voted positively once, asked the same thing again, and they voted not with the same numbers the second time. In fact, before the anti-defection law, which was inserted through the 52nd Amendment of 1985, was finally passed, there were previous attempts that were made in the late 70s, and they were not passed because you could not get it right the second time. Now, what is interesting about special majority 2 is it is only and only a parliamentary majority, which means only the Lok Sabha and the Rajya Sabha get to use this. The Lok Sabha votes twice and the Rajya Sabha votes twice. The two most popular ways to use special majority 2, because you're using a heavy majority, is to remove Supreme Court, High Court judges and to remove the Comptroller and the Auditor General, a very unique constitutional body which comes the closest to performing what is called an internal checks and balance function. That is why it is given the same kind of equivalence in terms of removal as a Supreme Court, High Court judge, and also a type of branded constitutional amendments under Article 368. We'll talk more about this just in a few minutes. So this is special majority 2. In terms of things within the Constitution, it is one of the most widely used. So this is like the simple majority for constitutional changes. Simple majority is the simple majority for out of constitutional changes. So bear that in mind. And then we finally have special majority 3. Now special majority 3 is a multi-layered majority. It is here where both the center and the states participate. Special majority 3 is basically special majority 2 plus something else. So what happens is, it starts at the Union Parliament, either the Lok Sabha or the Rajya Sabha, and you do exactly the same thing as special majority 2, which is you ask them once, more than half of the total strength. You ask them again, more than 2/3 of present and voting. Once both the houses have done this, you directly send this to all state legislatures and the legislatures of union territory. And amongst all, if half of them pass the same thing with simple majority, what you have is collectively state ratification. So this is constitutional changes through state ratification. So special majority 3 is special majority 2 plus state ratification. Half of the total number of regional legislatures have passed the same thing but using a simpler majority called simple majority. So special majority 3, the upper part of it is only used by the Lok Sabha and the Rajya Sabha, and the state part of it is by the regional legislatures. And it is only and only used for one thing, which is constitutional amendments under Article 368, a very special type. The amendments to the Constitution under 368 using special majority 3 and the amendments to the Constitution under 368 using special majority 2 are two completely different types of amendments to two completely different kinds of provisions in the Constitution. And finally, you've got special majority 4. Special majority 4 is nothing but the toughest majority that exists in the Constitution today. It is more than 2/3 of the total strength of that house. Now what happens here is you use it only for the Lok Sabha and the Rajya Sabha, nowhere else. And while you do this, you only and only use it for one simple purpose, which is the impeachment of the president. That is all that you would ever use these majorities for. Are we okay with this? Do we understand this? This is how you use your majorities. The toughest in terms of numbers, special majority 4. The toughest in terms of the sheer number of agencies involved is special majority 3. As you can see, special 1, 2, 3 and 4, all of them in some manner, form or another are federal implications. When you're creating a new All India service, which is basically a civil service recruited by the center, removed by the center, but they work at the states, has a federal implication. The states wanting a second chamber, a federal implication. Supreme Courts, our judgments are binding on the entire country. They listen to center-state disputes. High courts are the highest judicial organs in a state. The CAG reviews central action and state action. So there is a federal implication. These constitutional amendments have a very direct federal application, and the president, who has the powers to impose emergencies on states, is a federal implication, which is why these special majorities have a federal idea to them. And by the way, all of these terms, absolute, effective, simple, special 1, 2, 3 and 4, these terms are nowhere mentioned in the Constitution. These are commonly used terms. They are used for general reference. So in the prelims exam, you will always get full descriptions. You will always get full explanations. That, for example, the Supreme Court of India, a judge of the Supreme Court of India is removed by a majority of more than half of the total strength and a majority of more than 2/3 of present and voting, or not less than 2/3 of present and voting. That's generally how they write it. So this explains to you how our majorities run. Now we understood majorities are deeply used to make laws, which makes me move to the third topic. What are the different laws and what kind of majorities are required to make changes to those laws? We've studied types of laws, we studied types of majorities. Let us now merge them together and understand the application of majorities to lawmaking as topic number 3. The next topic, legislative changes. Applying majorities to lawmaking. Let's understand this. Our country has a hierarchy of laws. The constitution above every other law. So basically, when we talk about legislative changes, we refer to changes made to the constitution and changes made to any other law. Let's talk about the constitution and any format of changes. The first and the most important question is, can you replace the constitution? Can you delete the entire constitution? The answer to that is no, you cannot. Article 368 gives the power to the parliament to amend the constitution. And amendment is understood to be a change, not the replacement of the entire law. So the Constitution of India cannot be replaced with a new one entirely. You could do it provision by provision, is a different story. But can you replace the entire Constitution of India Act 1950 with the new Constitution of India Act 2024? You cannot. Can you delete the Constitution and say, we're not going to have any Constitution whatsoever? No. Because, not only because of 368, but the Supreme Court has also devised the doctrine of basic structure. So what can you do to the Constitution? You can add a provision, remove a provision, or change a provision, but a specific provision. And you can do so in 3 ways. Either using special majority 3, or using special majority 2, or using a simple majority. What's the difference? Special majority 3 is used specifically in those cases which are listed in black and white explicitly under Article 368. Clearly, as clear as day. Simple majority is to be used to change those articles in the Constitution where under those articles it is written that changes to these articles have nothing to do with Article 368. It would be clearly mentioned. And special majority 2 is where neither of the two things apply. Neither are those articles specially mentioned under 368, nor under those articles in black and white is it written that they have nothing to do with 368. And that's the general difference. The conceptual difference is special majority 3 is something which requires a federal implication. A simple majority constitutional amendment is something which showcases center stronger than the states, and everything else in the middle is a special 2 majority. Now, special majority 3 will have direct federal impact and indirect federal impact. Let's understand this. All of these are clearly categorically mentioned under Article 368, one of the golden articles of our Constitution. There are 10 things that are mentioned. What are directly federal are, for example, Article 54 and 55, which specifically deal with presidential elections. So any change to 54, any change to 55 will automatically require special majority 2. Similarly, Article 73 and 162, the executive powers of the union and the states, which is correlative to their legislative power. Article 279A which is the creation of the GST Council. Mind you, the GST Constitutional Amendment Act, the 101st Amendment, which introduced the concept of GST, did not require special majority 3 because the centre anyways had the powers to do so. But the GST Council Act changes the role of the centre and the states and the powers that they have to determine GST rates. So this would require special 3, but the 101st Amendment would require special 2. Chapter 1, Part 11, the legislative relations of the Union and the states, correlated to the 7th schedule. So you move anything from concurrent to state, state to concurrent, union to state, state to union. Any changes to the union list, the state list and the concurrent list would attract what is called special majority 3. And if you're changing the number of seats that the states would have to the Rajya Sabha, which is a federal chamber, a representative of state will, and the reason that you're changing those seats have nothing to do with territorial causes. For example, if you bifurcated Andhra Pradesh into Andhra Pradesh and Telangana, because of which Andhra Pradesh's Rajya Sabha seats share goes down and you have to allocate it to Telangana, this will not require special majority 3. In fact, this will require a simple majority as categorically mentioned under Article 4. But if you're changing the way Rajya Sabha elections are conducted, if you're changing the total seat share, it will require special majority 3. A simple example of special majority 2 is changes to Part 3. And under changes to Part 3, please understand this as clearly as you could. Under changes, for example, any fundamental right that is changed. For example, you added Article 21A, the right to education. It would require special majority 2. For example, you added EWS provisions under the 103rd Constitutional Amendment of 2019. Special majority 2. You made changes to 15 and Article 16 of the Constitution. And then you finally have a simple majority. Now with simple majority, the article categorically mentions under it that a change to this article will not require what is called a constitutional amendment under 368. In fact, you will not even use the word constitutional amendment despite the fact that you are changing the constitution. So for example, Article 4, which is territorial changes. So this would require simple majority. Article 169. Once, if you remember, we studied something that said that the State Legislative Assembly will pass a resolution using using special majority 1 that they want a State Legislative Council. When the Parliament actually creates the State Legislative Council, it does change a schedule in the Constitution, but it would require a simple majority because under Article 169, it is categorically given that it requires a simple majority. Similarly, under Article 243, if there is a parliamentary law that has to be made to extend Panchayati Raj institutions to scheduled areas or scheduled tribe areas, you would also require simple majority. Now, if you remember, I spoke to you about something called indirect federal impact. Indirect federal impact means still requiring special majority 3 will have a federal impact, but indirectly. So, for example, when you're making changes to the union and the state judiciary under Part 4, Chapter 4, Part 5, Chapter 5, Part 4. For example, now that constitutional amendment has been declared invalid, the 99th Constitutional Amendment, which had added the National Judicial Appointments Commission, would be a part of this too, and it would require special majority 3. The Supreme Court had effectively struck it down. Similarly, if you're making changes because of Article 241 2241, with respect to High Courts of Union Territories, you would still require special majority 3, because the High Courts are funded by the state governments. So it is going to be a burden on the state governments. And if you are changing Article 368 itself. So in a nutshell, are you changing the Constitution? Yes. Is it a serious federal change? It's a non-serious federal change, a non-federal change, and is it a unitary federal change? If that's the case, then you would have simple majority. If it's a non-serious federal change or a non-federal change, special 2, and if it's a serious federal change, you would require special majority 3. Because in all of these cases, federalism is at its backbone. And after all of this, make any changes to any law of any nature, does not matter whether you add a law, you remove a law, an entire law, a provision of a law, you will require what is called simple majority. Ordinary bill, money bill, financial bill 1, financial bill 2, doesn't matter. So effectively, anything which is outside the purview of a constitutional amendment under Article 368 is effectively simple majority. By knowing this, you can plot any law whatsoever. You will know this by simply understanding this particular table. And this takes care of my topic, legislative changes. And now is time to quickly go through my 4 golden rules that you are absolutely aware of. These rules serve 2 purposes. 1, it helps you take educated guesses when you don't know what the question is. And 2, it reinforces an answer that you would have known but might be confused because of the stress of the exam. There are 4 golden rules. Number 1, democratic mandate. Number 2, federal balance. And 3 and 4, which are generally studied together, separation of powers and checks and balances. Every concept, right from the preamble to the very last article of the Constitution, is justified on these 4 golden rules. Let's start with rule number 1, democratic mandate. Democratic mandate says, if you want to perform a democratic function, then you must have some form of democratic mandate. This function could be of any kind. This mandate could be of any kind. It could be a direct mandate, indirect mandate, full mandate, semi-mandate, any form. But some resemblance of mandate is required. Mandate means you have some affiliation to the people, which means higher the democratic function, higher would be the democratic mandate. Lower the democratic function, less advanced the democratic function, less advanced or lighter the mandate. Let's take a few examples. For example, for you to be a minister, you've got to be an MP. If you're not an MP at the time of becoming a minister, you've got 6 months to become an MP. Because as a minister, you're discharging the democratic function of executing policy, of formulating it, of initiating legislation. Those are core democratic functions. And the least we expect you to be is a member of parliament. Elected, nominated, does not matter, as long as you are a member of parliament. Because even if you are a nominated member of parliament, you could be from the Rajya Sabha, you're becoming a minister because the majority party in the Lok Sabha who gets to choose government wants you to be a member of parliament. Similarly, only elected MLAs participate in the Rajya Sabha elections. We used to have Anglo-Indian nominations, we don't anymore, but if that was the case, This is how it would be executed. And thirdly, let us say, elected members of the Lok Sabha, elected members of the Rajya Sabha, and elected members of the legislative assemblies of the state and the union territories participate in the election. Because if you're choosing a Rajya Sabha member, you're choosing the very first citizen of the country. The least we expect you to be is elected. This is also the reason why elected will always be superior to the appointed. This is why most of the outcomes of bodies of any nature are recommendatory in nature, because they're at the end of the day appointed bodies. It could also apply to an advanced concept as that of ordinances. Why are ordinances temporary laws? Because the ultimate law-making authority is still the legislature, which is why once the legislatures come back in session, they've got 6 weeks to pass the ordinance, and if they don't, the ordinance automatically lapses. This is why directive principles are not enforceable in a court of law, because you can't force the government to make a certain policy. So many applications from a simple principle which is called democratic mandate. My second rule is a federal balance rule. Now the federal balance rule has 3 sub-rules to it. Rule 1, or the first step, center stronger than the states. It could be in any form. The center would exert some form of superiority over the states. Then you will try to please the states, appease the states, make the states feel that they have not been wronged. And when you actually check the doing, you'll realize the pleasing and the appeasement was hollow, and ultimately the center was still stronger than the states. Let me give you 2 examples. This is also a very widely used rule. Territorial changes. The states have no role to play or have no powers of territorial changes. So if I am dividing Uttar Pradesh into Uttar Pradesh and Uttarakhand, Uttar Pradesh Legislative Assembly has no role. So the center is stronger than the states. How do I appease UP? Because UP is going to be upset. The president, before introducing the bill to the parliament, and the president has to introduce, because the president is symbolically elected by both the center and the states, so the presidential recommendation is needed. But also at the same time, before the president recommends this reorganization bill to the parliament, it will send the same bill for reference to the UP Legislative Assembly. Whatever the UP Legislative Assembly says or doesn't say, you can even put a time frame on it, is not binding on the president. So therefore, it is still hollow appeasement, and you would require all territorial changes